Question 1. Under the Uniform Securities Act, USAE, which of the following individuals would most likely be exempt from registration as an agent? A. An individual who represents an issuer in selling non-exempt securities to the general public. B. An individual who represents a broker-dealer in selling exempt securities to existing retail clients. C. An individual who represents an issuer in effecting transactions in its non-exempt securities with its existing employees, provided no commission is paid for the solicitation. D. An individual who represents an investment advisor in soliciting new advisory clients. Answer: C. An individual who represents an issuer in effecting transactions in its non-exempt securities with its existing employees, provided no commission is paid for the solicitation. The Uniform Securities Act provides an exemption from agent registration for individuals representing an issuer when effecting transactions in the issuer's own securities with its employees, partners, or directors, provided no commission or other remuneration is paid directly or indirectly for soliciting purchasers. This exemption primarily applies to non-exempt securities. Selling non-exempt securities to the general public, option A, or selling any securities for a broker-dealer, option B, typically requires agent registration. Soliciting advisory clients for an investment advisor, option D, requires IAR registration, not agent registration. Question 2. An investment advisor representative, IAR, is providing advice to a client who wants to diversify their portfolio. The IAR suggests purchasing a specific mutual fund but fails to disclose the 12b-1 fees associated with the fund. This action is considered A minor oversight that does not violate the Uniform Securities Act, USAE. B. An acceptable practice if the client is sophisticated. C. A deceptive practice and a violation of the USA's anti-fraud provisions. D. Permissible, as long as the 12b-1 fees are disclosed in the fund's prospectus. Answer: C. A deceptive practice and a violation of the USA's anti-fraud provisions. Failing to disclose significant fees, such as 12b-1 fees, when recommending a mutual fund constitutes a material omission and is considered a deceptive practice. This directly violates the anti-fraud provisions of the Uniform Securities Act because clients are entitled to full disclosure of all material facts, including costs, when receiving investment advice. Even if the fees are in the prospectus, the IAR has an affirmative duty to highlight and explain material aspects of a recommendation to their client, making this a clear violation of fiduciary duty and ethical conduct. Question 3. Which of the following is not a security under the Uniform Securities Act, USAE? A. An investment contract in a citrus grove. B. A fixed annuity contract. C. A variable annuity contract. D. An oil and gas limited partnership interest. Answer: B. A fixed annuity contract. Under the Uniform Securities Act, USAE, a security is broadly defined, but certain instruments are specifically excluded. A fixed annuity contract is typically considered an insurance product, where the insurance company bears the investment risk, and it is explicitly excluded from the definition of a security. In contrast, variable annuity contracts, investment contracts, like those in a citrus grove, and limited partnership interests are generally considered securities because they involve an investment of money in a common enterprise with the expectation of profits to be derived primarily from the efforts of others, thus subjecting them to securities regulation. Question 4. A broker-dealer's agent takes an order from a client without ensuring the recommendation is suitable for the client's investment objectives and financial situation. This practice is known as A. Churning. B. Front-running. C. Selling away. D. Unsuitable recommendation. Answer, D. Unsuitable recommendation. Making an unsuitable recommendation occurs when a broker-dealer or agent recommends a security or strategy that is inconsistent with a client's investment profile, including their objectives, risk tolerance, and financial situation. This is a significant violation of ethical conduct and regulatory requirements under the Uniform Securities Act. Churning involves excessive trading to generate commissions, front-running is trading ahead of client orders, and selling away is selling securities not offered through the firm, all of which are distinct prohibited practices. Ensuring suitability is a fundamental duty of agents to protect their clients' interests. Question 5. Under the Uniform Securities Act, the administrator may require a minimum net capital for which of the following registrants? A. Agents. B. Investment advisor representatives, IARs. C. Investment advisors, IAs. D. Issuers. Answer, C. Investment advisors, IAs. The administrator has the authority under the Uniform Securities Act to establish minimum net capital requirements for broker-dealers and investment advisors. This requirement ensures that these firms maintain sufficient financial stability to meet their obligations and protect clients. Agents and investment advisor representatives, IARs, are individuals who work for these firms, and as such, they are not typically subject to individual net capital requirements. Issuers, while subject to registration requirements for their securities, are not subject to net capital rules set by the administrator for firms in the business of providing advisory or brokerage services. Question 6. Which of the following would not be considered an offer or offer to sell under the Uniform Securities Act? A. A newspaper advertisement for a new stock offering. B. A preliminary prospectus, red herring. C. A research report on a company being acquired, distributed after the acquisition is complete. D. An oral solicitation to purchase a bond. Answer, C. A research report on a company being acquired, distributed after the acquisition is complete. Under the Uniform Securities Act, an offer or offer to sell includes any attempt or solicitation to dispose of a security or an interest in a security for value. This definition is very broad and includes advertisements, preliminary prospectuses, and oral solicitations related to an ongoing or prospective transaction. However, a research report distributed after an acquisition is complete, which simply provides information or analysis without attempting to induce a sale of a security related to that transaction, would generally not be considered an offer. Its purpose is informational, not transactional. Question 7. An agent registered in State A decides to move to State B and continue working for the same broker-dealer. To lawfully continue their activities, the agent must A. Only notify their broker-dealer of the change of address. B. Re-register in State B within 30 days of the move. C. Register in State B before transacting any business there. D. Wait until their current registration expires before registering in State B. Answer, C. Register in State B before transacting any business there. Under the Uniform Securities Act, an agent must be registered in every state in which they transact business. When an agent moves to a new state and intends to continue acting as an agent, they must register in that new state before conducting any business there. Simply notifying the broker-dealer or waiting a specific number of days is insufficient. Prior registration is mandatory to ensure compliance with state securities laws. This requirement safeguards investors by ensuring that all individuals offering securities are properly qualified and supervised in the jurisdiction where they operate. Question 8. Which of the following circumstances would automatically trigger a statutory disqualification for an applicant seeking registration as an agent? A. A civil lawsuit alleging breach of contract, currently pending. B. A felony conviction for a non-securities related offense 15 years ago. C. A misdemeanor conviction involving the sale of alcohol 2 years ago. D. An injunction by the SEC against the individual's participation in the securities industry, entered 3 years ago. Answer, D. An injunction by the SEC against the individual's participation in the securities industry, entered 3 years ago. A statutory disqualification is a serious regulatory penalty that can prevent an individual from registering or remaining registered in the securities industry. It is triggered by specific events, such as convictions for any felony or certain misdemeanors within the past 10 years, or injunctions issued by regulators like the SEC or a state administrator prohibiting participation in the industry. An injunction from the SEC directly preventing an individual from participating in the industry would certainly lead to statutory disqualification, as there is no time limit for such injunctions. A felony conviction, securities-related or not, must have occurred within the last 10 years to be an automatic disqualifier. A non-securities-related misdemeanor typically does not result in an automatic disqualification. Question 9. An investment advisor, IAE, registered with the SEC is required to file a notice filing with the state administrator if they A.e. no place of business in the state and advise fewer than 6 institutional clients. B. A place of business in the state. C. No place of business in the state but have fewer than 6 retail clients in the state. D. Assets under management, AUM, exceeding $110 million. Answer, B. A place of business in the state. Investment advisors registered with the SEC, federal covered advisors, are generally exempt from state registration. However, states can still require a notice filing if the federal covered advisor has a place of business in that state. Option C describes having fewer than 6 retail clients, which would typically qualify for a de minimis exemption, making it incorrect. Advisors with no place of business in the state but who manage assets for 6 or more retail clients would also require a notice filing. The AUM exceeding $110 million, option D, is the threshold for mandatory SEC registration, not a condition for state notice filing. The most direct trigger among the correct options for a notice filing is having a physical presence, a place of business, in the state. Question 10. The administrator may revoke an agent's registration if the agent has A.e. been found liable in a civil arbitration for a minor breach of contract. B. Made an unintentional clerical error in a client's account statement. C. Willfully violated the Uniform Securities Act. D. Failed to meet a sales quota set by their broker-dealer. Answer, C. Willfully violated the Uniform Securities Act. The administrator has broad powers to deny, suspend, or revoke registrations for various reasons, but a willful violation of the Uniform Securities Act is a primary and explicit ground for such action. This signifies an intentional disregard for the law and its regulations, posing a direct threat to investor protection. Minor civil liabilities, unintentional errors, or internal sales performance issues are generally not grounds for revocation, as they do not indicate a willful disregard for securities law. The administrator's powers are designed to enforce compliance and protect the public from fraudulent or unethical practices. Question 11. Under the Uniform Securities Act, which of the following is not typically considered an exempt security? A.e. Securities issued by the U.S. government. B. Securities issued by a state or political subdivision. C. Securities issued by a publicly traded Canadian corporation. D. Securities issued by a bank organized under U.S. laws. Answer, C. Securities issued by a publicly traded Canadian corporation. Exempt securities under the Uniform Securities Act are those that, due to their inherent nature or issuer, are deemed to carry a low risk of fraud and are thus exempt from the registration requirements of the Act. These typically include securities issued by the U.S. government, state and municipal governments, and banks and trust companies organized under U.S. laws. Securities issued by a publicly traded Canadian corporation, while potentially registered federally, are not automatically considered exempt securities under the USA at the state level merely by virtue of being Canadian. They would likely need to be registered or qualify for a transaction exemption to be sold in a state. Question 12. A client receives a prospectus for a new issue from an agent. The agent then calls the client to highlight certain aspects of the offering, specifically focusing on the potential for quick profits. This action is A. Permissible, as long as the prospectus was provided. B. A violation of the anti-fraud provisions of the USA. C. Acceptable, if the agent believes the client is sophisticated enough to understand the risks. D. Required, as part of the agent's duty to explain the investment. Answer, B. A violation of the anti-fraud provisions of the USA. Highlighting specific aspects of an offering, especially potential profits, without adequately balancing them with risks, or making misleading statements that aren't fully supported by the prospectus, is a violation of the anti-fraud provisions of the Uniform Securities Act. Agents have a duty to present a balanced view and avoid exaggeration or omission of material facts, even if a prospectus has been delivered. Focusing solely on potential quick profits without discussing the corresponding risks or limitations constitutes a deceptive and unethical sales practice, regardless of the client's perceived sophistication. Question 13. When must an investment advisor's brochure, Form ADV Part 2 AE, be delivered to a client? AE. At least 48 hours after entering into an advisory contract. B. No later than the time of entering into an advisory contract. C. Annually, within 90 days of the firm's fiscal year end. D. Only upon request from the client. Answer, B. No later than the time of entering into an advisory contract. The Uniform Securities Act, USAE, and SEC rules require that an investment advisor's brochure, Form ADV Part 2 AE, be delivered to a client no later than the time of entering into an advisory contract. This ensures that prospective clients receive critical information about the advisor's services, fees, disciplinary history, and conflicts of interest before committing to the relationship. While there are also annual delivery requirements or offers to deliver, the initial delivery before or at the contract signing is crucial for informed consent. There is also a rule allowing delivery within 48 hours of contract signing, provided the client has a 5-day right to terminate without penalty, but no later than the time of entering is the more encompassing and generally applicable rule for initial delivery. Question 14. Which of the following persons is not included in the definition of an investment advisor representative, IR, under the Uniform Securities Act? AE. An individual who determines which recommendations or advice should be given to advisory clients. B. An individual who supervises employees performing advisory functions. C. An individual who solicits, offers, or negotiates for the sale of investment advisory services. D. An individual who provides only clerical or ministerial support to an investment advisor. Answer, D. An individual who provides only clerical or ministerial support to an investment advisor. An investment advisor representative, IAR, is an individual who works for or is associated with an investment advisor and performs specific advisory functions. This includes individuals who give advice, supervise those who give advice, or solicit clients for advisory services. However, individuals whose functions are solely clerical or ministerial, meaning they do not directly provide advice, solicit clients, or supervise advisory personnel, are typically excluded from the definition of an IAR. Their role is administrative support rather than direct advisory or sales activity. Question 15. An administrator may issue a stop order against an exempt security under what circumstances? A. Never, as exempt securities are permanently exempt from all provisions of the USA. B. If the administrator finds that the security is being offered in violation of the anti-fraud provisions. C. Only if the issuer has defaulted on its debt obligations. D. If the issuer fails to provide a financial report within 30 days of request. Answer, B. If the administrator finds that the security is being offered in violation of the anti-fraud provisions. While exempt securities are typically exempt from registration requirements under the Uniform Securities Act, they are not exempt from the anti-fraud provisions. If the administrator discovers that an exempt security is being offered in a fraudulent or deceptive manner, they absolutely have the power to issue a stop order or take other enforcement actions to protect the public. The exemption from registration does not provide immunity from rules designed to prevent deceitful practices in the sale of securities. This distinction is critical for investor protection. Question 16. Regarding the registration of securities under the Uniform Securities Act, which method is typically used for established companies that have previously registered securities with the SEC? A. Registration by qualification. B. Registration by coordination. C. Registration by notification, filing. D. Registration by exemption. Answer, B. Registration by coordination. Registration by coordination is the method primarily used for securities that are being registered simultaneously with the SEC under the Securities Act of 1933 and with one or more states under the Uniform Securities Act. This method coordinates the state registration process with the federal registration, often requiring the filing of copies of documents submitted to the SEC. Registration by qualification is for intrastate offerings or those not federally registered. Registration by notification, filing, is a simplified method for well-established companies with specific financial track records, while registration by exemption is not a method of registration itself, but rather indicates that a security does not need to be registered. Question 17. An agent informs a client that they will personally share in any profits generated from the client's new investment, while also agreeing to bear a portion of any losses. This arrangement is A. Permitted if the agent receives written authorization from the client and the broker-dealer. B. A violation of the anti-fraud provisions of the Uniform Securities Act, as sharing in profits or losses is generally prohibited. C. Allowed only if the client is an institutional investor. D. Acceptable as long as the agent does not solicit the arrangement. Answer, B. A violation of the anti-fraud provisions of the Uniform Securities Act, as sharing in profits or losses is generally prohibited. Sharing in the profits or losses of a client's account is a prohibited practice for agents under the Uniform Securities Act, regardless of client consent or the agent's intention. This rule is in place to prevent conflicts of interest and ensure agents act solely in the client's best interest. There are very limited exceptions, typically involving joint accounts with certain individuals, e.g., a family, and specific broker-dealer approval, but direct profit/loss sharing for advisory or transactional services is generally forbidden. Question 18. A broker-dealer's core books and records, such as blotters and ledgers, must be preserved for a minimum period of A. 3 years. B. 5 years. C. 6 years. D. 7 years. Answer, C. 6 years. Under the Uniform Securities Act, USAE, and consistent with common state regulatory practice which often mirrors federal standards, like SEC Rule 17A4, broker-dealers are generally required to preserve certain core books and records, such as blotters, ledgers, and customer account records, for a minimum period of 6 years. Other records, like correspondence, typically have a 3-year retention requirement. For general books and records referring to fundamental operational and client account information, 6 years is the standard minimum to ensure comprehensive regulatory oversight and investor protection. Question 19. An agent discovers that a client has provided false information regarding their net worth on an account application. The agent should A. Proceed with the account opening as the client is responsible for their own information. B. Correct the information discreetly without informing the client. C. Notify their supervisor immediately and refuse to open the account until the correct information is provided. D. Open the account but only recommend conservative investments. Answer: C. Notify their supervisor immediately and refuse to open the account until the correct information is provided. Upon discovering that a client has provided false information on an account application, an agent has an ethical and regulatory obligation to notify their supervisor immediately. The agent should not proceed with opening the account until accurate information is provided and verified. Opening an account with false information could lead to unsuitable recommendations, potential fraud, and regulatory violations for both the agent and the broker-dealer. Protecting the integrity of client information and complying with suitability rules is paramount, making immediate reporting and corrective action essential. Question 20. Which of the following actions by an investment advisor would be considered a prohibited practice under the Uniform Securities Act? A. Charging different fees to different clients based on services rendered and disclosed in the brochure. B. Exercising discretion in a client's account without obtaining written authorization. C. Maintaining custody of client funds and securities with proper safeguards and disclosure. D. Entering into a performance-based fee arrangement with a qualified client. Answer: B. Exercising discretion in a client's account without obtaining written authorization. Exercising discretion in a client's account without obtaining prior written authorization is a serious prohibited practice for an investment advisor. Discretionary authority grants the advisor the power to make investment decisions, what security, how much, and when, without prior client approval for each trade, requiring explicit written consent to prevent unauthorized trading. While charging different fees or maintaining custody are permissible if done according to strict regulatory guidelines and disclosures, and performance-based fees are allowed for qualified clients, unauthorized discretionary trading is a direct violation of fiduciary duty and client trust. Question 21. A person is deemed to be a federal covered advisor if they A. Manage client assets totaling less than $25 million. B. Advise only municipal issuers. C. Are required to register with the SEC under the Investment Advisors Act of 1940. D. Provide investment advice solely to family members. Answer: C. Are required to register with the SEC under the Investment Advisors Act of 1940. A federal covered advisor is an investment advisor that is required to register with the Securities and Exchange Commission, SEC, under the Investment Advisors Act of 1940. This typically applies to advisors managing $110 million or more in client assets, advising registered investment companies, or operating in 15 or more states. Advisors with less than $25 million in AUM or those advising only family members are generally subject to state registration or exemptions. Advising only municipal issuers does not automatically make one a federal covered advisor, although they might still meet the AUM thresholds. The key defining factor is the requirement for SEC registration. Question 22. An agent receives a written complaint from a client alleging significant losses due to an unsuitable investment. The agent's first action should be to a. Contact the client immediately to resolve the issue directly. b. Forward the complaint to their immediate supervisor or compliance department. c. Discard the complaint if it appears frivolous. d. Consult with a personal attorney before taking any action. Answer: B. Forward the complaint to their immediate supervisor or compliance department. Upon receiving a written complaint from a client, an agent's primary and immediate responsibility is to forward it to their immediate supervisor or the firm's compliance department. Broker-dealers and investment advisors have established procedures for handling client complaints, and agents are generally prohibited from attempting to resolve such matters independently. This ensures that the complaint is properly documented, investigated, and addressed in compliance with regulatory requirements, protecting both the firm and the client. Discarding the complaint, contacting the client directly without supervision, or consulting a personal attorney before firm notification are all inappropriate initial responses. Question 23. Under the Uniform Securities Act, the term person includes all of the following except a. An individual. b. A corporation. c. An estate. d. A minor. Answer: D. A minor. Under the Uniform Securities Act, the definition of a person is very broad and includes individuals, corporations, partnerships, trusts, estates, and other legal entities. This comprehensive definition ensures that most entities or individuals involved in securities transactions can be subject to the Act's provisions. However, a minor, while an individual, typically lacks the legal capacity to enter into binding contracts for securities, and thus, accounts for minors are usually opened under the Uniform Gifts to Minors Act, UGMA, or Uniform Transfers to Minors Act, UTMA, by a custodian, not directly by the minor themselves. Therefore, a minor is generally not considered a person in the context of directly engaging in securities transactions for regulatory purposes. Question 24. Which of the following statements about a cease and desist order issued by the administrator is most accurate? a. It can only be issued after a formal hearing has been conducted. b. It is a temporary order used to halt prohibited activities immediately. c. It requires a court order before it can be enforced. d. It can only be issued against broker-dealers, not agents or investment advisors. Answer: B. It is a temporary order used to halt prohibited activities immediately. A cease and desist order is a powerful tool used by the administrator to immediately stop a person from engaging in activities that are in violation of the Uniform Securities Act. These orders are often issued summarily, meaning without prior notice or a formal hearing, to prevent ongoing harm to the public. While a hearing may be offered or requested after the order is issued, the initial order does not require one beforehand or a court order for enforcement. It can be issued against any person, including agents, broker-dealers, investment advisors, and IARs, who are found to be violating the Act. Question 25. An agent engages in selling away by executing a private securities transaction for a client without notifying their broker-dealer. This is a violation because a. The agent's broker-dealer loses out on potential commissions. b. The client is not protected by the broker-dealer's supervision and compliance procedures. c. The transaction may be illegal if it's not registered with the SEC. d. The agent might be paid by two different entities for the same transaction. Answer: B. The client is not protected by the broker-dealer's supervision and compliance procedures. Selling away occurs when an agent effects a securities transaction for a customer outside the regular course or scope of their employment with their broker-dealer, without the firm's knowledge or approval. This is a serious violation because it bypasses the broker-dealer's supervisory system, leaving the client vulnerable to fraud, misrepresentation, or unsuitable recommendations without the firm's oversight and protections. While lost commissions and potential illegality of the security itself are concerns, the primary regulatory focus is on the lack of supervision and the resulting investor protection risk. All transactions by an agent must be processed through and supervised by their employing broker-dealer. Question 26. An investment advisor, IAE, takes custody of client funds and securities. Which of the following is not a required safeguard under the Uniform Securities Act? A. Notifying the administrator of such custody. B. Maintaining client funds and securities in a separate account for each client. C. Sending account statements to clients at least quarterly. D. Being subject to an annual unannounced audit by an independent public accountant. Answer, B. Maintaining client funds and securities in a separate account for each client. While investment advisors must maintain client funds and securities in a separate account or accounts, the requirement is not for a separate account for each client if proper safeguards are in place. Instead, they must be segregated from the IA's own assets and held in a qualified custodian's name or in a separate account under the client's name. Advisors taking custody must notify the administrator, send account statements at least quarterly, and be subject to an annual unannounced audit. The key is segregation from the IA's own assets and proper record keeping, not necessarily an individual separate account for every single client, especially if using a qualified custodian. Question 27. A broker-dealer allows a client to place an order for a security without updating their client profile, which is now several years old. This could primarily be a violation of the rule regarding A. Disclosure of control relationships. B. Timely execution of orders. C. Suitability. D. Delivery of prospectuses. Answer, C. Suitability. Allowing a client to place an order without an updated client profile can lead to a violation of the suitability rule. To make suitable recommendations, a broker-dealer and its agents must have accurate and current information about the client's investment objectives, financial situation, and risk tolerance. An outdated profile means the firm may not have the necessary information to determine if a recommended transaction is appropriate for the client, increasing the risk of an unsuitable recommendation. While the other options are also important regulations, the lack of current client information directly impacts the ability to assess suitability. Question 28. Which statement best describes the administrator's power to inspect the records of a broker-dealer? A. The administrator may inspect records only with a court order. B. The administrator may inspect records at any time, but only during normal business hours. C. The administrator may inspect records at any time, within or without the state, as they deem necessary. D. The administrator must give 24-hour prior notice before inspecting records. Answer, C. The administrator may inspect records at any time, within or without the state, as they deem necessary. Under the Uniform Securities Act, the administrator has broad powers to conduct examinations and inspections. This includes the right to inspect the books and records of any broker-dealer or investment advisor registered in their state at any time, within or without the state, as they deem necessary to ensure compliance with the Act. This power is crucial for effective regulatory oversight and investor protection, and it does not typically require a court order or prior notice. Inspections are a fundamental aspect of the administrator's enforcement capabilities. Question 29. An investment advisor's promotional material includes a chart showing only the highest performing client portfolios over the past 5 years, while omitting information about underperforming accounts. This practice is A. Permissible, as advisors are only required to highlight their best work. B. A violation of the anti-fraud provisions of the Uniform Securities Act, as it constitutes cherry-picking and misrepresentation of performance. C. Acceptable, provided a disclaimer states that past performance is not indicative of future results. D. Allowed, as long as the advisor does not explicitly claim the results are typical for all clients. Answer, B. A violation of the anti-fraud provisions of the Uniform Securities Act, as it constitutes cherry-picking and misrepresentation of performance. Presenting only the highest-performing client portfolios while omitting others is known as cherry-picking and is a deceptive practice. It creates a misleading impression of the advisor's overall success and can defraud potential clients. All advertising and promotional materials must be fair, balanced, and not misleading, providing a representative sample of performance where applicable, and fully disclosing all material facts. This directly violates the anti-fraud provisions of the Uniform Securities Act. Question 30. An agent of a broker-dealer must be registered in a state if they a.e. affect transactions only with institutional investors in that state. b. have a place of business in the state, even if they only communicate with clients in other states. c. only publish research reports to clients in that state but do not execute trades. d. are supervised by a registered agent in that state. Answer, B. have a place of business in the state, even if they only communicate with clients in other states. Under the Uniform Securities Act, an agent must be registered in a state if they have a place of business in that state, regardless of where their clients are located. The physical presence in the state triggers the registration requirement. While an agent typically needs to be registered if they effect transactions or solicit business from retail clients in a state, having a place of business is a direct and clear trigger for state registration. Affecting transactions only with institutional investors or only publishing research reports might still require registration depending on the specific activities, but having a place of business is a definitive requirement. Question 31. An investment advisor's website contains testimonials from current clients. Under the Uniform Securities Act, USAE, considering modern interpretations, this practice is a. permitted without restriction as long as they are truthful. b. prohibited in all circumstances. c. permitted only if the advisor complies with specific disclosure requirements, including any compensation or conflicts of interest. d. permitted only if the testimonials are from non-advisory clients. Answer, C. Permitted only if the advisor complies with specific disclosure requirements, including any compensation or conflicts of interest. Under the Uniform Securities Act, as interpreted through NASAA's adoption of the SEC's marketing rule, Rule 206, 4-1 under the Investment Advisors Act of 1940, investment advisors are now generally permitted to use testimonials from current clients. However, this practice is subject to strict disclosure requirements, including clear disclosure of whether the testimonial giver is a client, any compensation paid, and any material conflicts of interest. Misleading testimonials remain prohibited. Therefore, stating they are generally prohibited is no longer accurate, and they are permitted under specific, well-defined conditions. Question 32. Which of the following is an example of an exempt transaction under the Uniform Securities Act? A.e. an initial public offering, IPO, of a new technology company. B. a non-issuer transaction in an outstanding security that is subject to federal reporting requirements. C. a public offering of a security not previously registered. D. an offering of a security where the proceeds are used to fund a political campaign. Answer, B. a non-issuer transaction in an outstanding security that is subject to federal reporting requirements. Exempt transactions are those types of sales or offerings that do not require registration under the Uniform Securities Act, usually because they involve sophisticated parties, limited numbers of offerees, or a lack of public solicitation, making investor protection concerns less paramount. A common exempt transaction is a non-issuer transaction, a sale by someone other than the issuer, like a trade on an exchange, in an outstanding security that is subject to federal reporting requirements, e.g., listed on a major exchange. IPOs and public offerings of unregistered securities typically require registration. An offering funding a political campaign is not a recognized exemption. Question 33. The administrator has the authority to deny, suspend, or revoke a registration for any of the following reasons except a. The applicant has filed an incomplete application. b. The applicant was found liable in a civil arbitration for a minor contractual dispute 2 years ago. c. The applicant has violated a rule or order of the administrator. d. The applicant is currently subject to a temporary injunction by a court of competent jurisdiction prohibiting them from engaging in the securities business. Answer, B. The applicant was found liable in a civil arbitration for a minor contractual dispute 2 years ago. The administrator has broad powers to deny, suspend, or revoke registration based on specific criteria outlined in the Uniform Securities Act. These grounds include filing an incomplete application, violating the Act or the administrator's orders, or being subject to a court injunction in the securities business. A felony conviction, even if not securities-related, within the past 10 years is also an explicit ground for statutory disqualification. However, being found liable in a minor civil contractual dispute, without further evidence of willful securities law violations or unfitness, would typically not be a sufficient ground for the administrator to deny, suspend, or revoke a securities registration. Question 34. An agent learns that a major institutional client is about to place a large buy order for XYZ stock, which is likely to significantly drive up the price. Before executing the client's order, the agent places a personal buy order for XYZ stock in their own account. This action is known as A. Shadowing, B. Churning, C. Front-running, D. Painting the tape. Answer, C. Front-running. This scenario describes front-running, a prohibited practice where an agent, or firm, places a personal order for a security with knowledge of a pending client order that is likely to affect the security's price. This allows the agent to profit at the expense of the client or other market participants and is a clear violation of anti-fraud provisions and fiduciary duties. Churning involves excessive trading in a client's account to generate commissions. Painting the tape is a manipulative practice involving creating artificial activity to mislead the market. Shadowing is not a recognized prohibited practice in this context, although shadow trading is a term for similar practices. Question 35. Which of the following would require an individual to register as an agent under the Uniform Securities Act? A. An individual who represents an issuer in selling its own commercial paper with a maturity of 270 days. B. An individual who represents a broker-dealer in purchasing securities for the firm's own investment account. C. An individual who represents a broker-dealer in selling mutual fund shares to the public. D. An individual who represents an issuer in a transaction with an underwriter. Answer, C. An individual who represents a broker-dealer in selling mutual fund shares to the public. An agent is defined as an individual who represents a broker-dealer or issuer in effecting or attempting to effect purchases or sales of securities. Representing a broker-dealer in selling mutual fund shares to the public clearly falls under this definition and requires agent registration. In contrast, an individual representing an issuer in selling its own commercial paper with a maturity of 270 days or less would be exempt from agent registration because commercial paper meeting these criteria is an exempt security under the USA. Similarly, purchasing securities for the firm's own account is generally not an agent function, and representing an issuer in a transaction with an underwriter is typically covered by the issuer's exemption or the underwriter's own registration.